These are in listen-only mode.
Hello, welcome. We're just going to give it another minute or two as attendees are just coming on now. Hello, this is Amy O'Hara. I'm a partner with the law firm of Littman Krooks, and our firm practices and focuses in the areas of elder law, guardianship, special needs planning, estate and trust administration, and special education advocacy. Today, I'm going to be speaking with you about special needs planning, protecting a personal injury settlement. I'm going to have a little bit of back and forth. My slides will follow my conversation. I may jump around a little bit, but you know, you'll be able to follow along. Also, on the right-hand side, you should be able to write questions, and under the chat button, and make sure the chat arrow is down so you could see, and then where it says to, you should see if you could have it go to me as the presenter. There should be an option to send questions to the presenter. And I likely will not be answering them during my presentation, but I'll look at them at the end. So when we're thinking about personal injury settlement, as a special needs planning lawyer, I get involved in cases frequently that involve plaintiffs that have significant cognitive impairment, as well as physical impairments. Today, we're going to focus more on the cognitive impairment aspect and the litigation settlement. But by all means, it's not limited to that, this planning. It's important when the plaintiff's attorney gets involved to examine what the statute of limitations is. So if there is a birth-related injury or an injury during somebody's lifetime from a car accident or some other personal injury, there is what we refer to as a statute of limitations. So there's a time period that can be brought, where the case can be brought. Otherwise, if you're beyond that limitations, then you are not able to bring that litigation, commence that litigation. And some individuals that are infants, minors, or have disabilities, sometimes the statute is told and it will be expanded for some time to allow the infant or the individual with the disability to be able to commence the action. So a couple terms just to focus on right away, guardian ad litem versus guardian. These are different aspects to litigation that often causes confusion to my clients. A guardian ad litem is usually a lawyer that is appointed to represent the incapacitated individual, whether they're a minor or they have a cognitive impairment, and their authority is limited for the specific purpose that they were appointed, mainly the litigation. And they will represent the individual during the litigation. A guardian is usually permanent, or not limited. If it's not permanent, at least not limited to that instant litigation. And a guardian can be guardian of the person and or property. And they're charged with investing assets, paying bills, making medical decisions, applying for government benefits. And in New York, we have two main statutes where we apply for guardianship. It's under Article 81, which is in our Supreme Court, and Article 17A, which is in our surrogates court. Article 81, oftentimes, actually, Article 17A, that guardianship is limited to individuals who have intellectual and developmental disabilities, where the disability occurred before the age of 22. Now, a lot of our plaintiffs under these personal injury litigations will meet that requirement to be able to apply for guardianship under Article 17A. However, because their action was commenced in New York Supreme Court, which is our lowest trial court, oftentimes in Article 81 guardianship is pursued. And that is a guardianship that is open to all types of cognitive impairments, not limited to intellectual or developmental disabilities, but can expand upon individuals who become disabled through cognitive impairments later in life. Also, if we're dealing with an individual with a cognitive impairment or who is an infant, there is a compromise order that is done at the conclusion of the litigation, and that gives the judges authority to be able to settle to approve the settlement of the litigation on behalf of the infant or the individual with a cognitive disability. And in that order, it's going to set forth all of the requirements that typically that the family or the plaintiff must follow with the settlement going forward. And so all of my discussion today is going to focus on whether there's a need for benefits, public benefits or not. And public benefits are broken down into what I say means tested and not means tested, meaning is there a financial asset test or income test? And if there is, then we look at what resources and income is available and counted to determine eligibility for those programs. And so programs that are not based upon somebody's income and assets or Social Security disability, SSDI, Medicare, and special education. Public benefits that are determined based upon income and assets are SSI, Medicaid, certain VA benefits, SNAP, which are food stamps, certain housing and utility subsidies, waiver programs through OPWDD, and certain state benefits. So in New York, an individual in 2019 can receive a total of $858 of supplemental security income, SSI, if they're living alone. And that's a $771 month federal benefit with a state supplement of $87. And oftentimes that benefit is very important to protect for individuals with disabilities because they don't have the ability to have income from other sources. And coupled with that, in New York, if you're eligible for SSI, you receive automatic Medicaid eligibility. And Medicaid eligibility is extremely important for many individuals, not just to provide for basic health insurance, but also to provide for various waivered services or care, critical care beyond the basic health insurance coverage. So why involve a special needs attorney in a personal injury litigation settlement? There's many reasons, and the sooner that a special needs attorney is brought in, the better the family is protected, because the better they have understanding different concepts that are not necessarily the personal injury attorney is focused on throughout the duration of the litigation. So as a special needs attorney, we provide government benefits advocacy, and there's certain intricacies in there. So for example, if we're dealing with a plaintiff who is close to turning 65 years old, then a lot of our rules change and they become more restrictive. And so our involvement along the way can come up with various strategies to try to protect any settlement. A plan, putting in the plan for when the case settles. What type of trust are we going to use, or are we not going to use a trust? Do we have court oversight of the settlement? Are we concerned with the guardianship? Are the funds being held in joint control with the court? And do we have to receive permission to withdraw those funds? And it's also setting expectations. So most families understand that any type of settlement that a plaintiff beneficiary receives is for that beneficiary. But sometimes the families have certain expectations or understandings that they can use these settlement funds for beyond what they're really permitted to do under the rules and regulations. And it's education, working with the family to understand that. So when, and many times, depending on the size of the settlement, a portion of the settlement is structured into an annuity so that it's paid out over the course of the individual's lifetime or for a set number of years. And it's also balancing that structure with immediate needs for the beneficiary. And you know, what are the immediate needs? And so it's a balance of making sure that enough assets are not put into the structure and are available for investment for extraordinary expenses, that we can't be dependent upon the stream of income coming in from the structure, but also sometimes there's certain housing allowances that we need to be concerned with, or certain improvements that need to be made. And so we want to be able to structure that, I don't want to use the word structure, but have that, you know, sort of pool of money set aside, whether it's in a trust or a guardianship account, to be able to offset so we're not dependent solely upon that structure coming in. And so oftentimes a budget is put into place about, you know, what's this beneficiary's life expectancy, what are their living expenses, what extraordinary expenses do we anticipate in the near and long-term future when all of this is factored in determining the settlement. And again, I come in from the special needs planning perspective, certainly not for the personal injury analysis part of the case and the value of the case that way. And then when the settlement or the award is received, how is that money coming in? Is it going to be established in a trust or, you know, put into a trust? Is it going to be put into a guardianship account? And you know, in dealing with the trust, and the guardianship account I'll talk about a little bit later, but with the trust, are we focused on a settlement trust or a special needs trust? A special needs trust is not the only option. It's probably one of the most talked about, but it's not always the best option. And sometimes we don't need to be subject to such restrictions as a special needs trust has, and we could be less restrictive in the terms of a settlement trust. So today, for the rest of my conversation will be focused on special needs trusts, and in that will be first-party special needs trusts and pooled special needs trusts. Today's conversation will not be focused on third-party special needs trusts. I have other webinars that are available on our website that you can look, where I focus more on third-party trusts. And so I always say, what's in the name of a special needs trust? Because it's referred to as many different, and again, I'm really talking about the first star here, the first party special needs trust. You know, it's oftentimes referred to as what we say a D4A trust, which is based upon our federal statute of 42 USC 1396P D4A. I'm never expected for you to remember that, but that's where the term D4A comes from. We refer to as a first party trust or a payback trust or a self-settled trust. All of these concepts I'll explain a little bit in a bit, or exception trust, or even a supplemental needs trust. In New York, the terms special needs trust and supplemental needs trust are used interchangeably, and one does not necessarily mean a first party or a third party. So first party special needs trusts are created with the assets or income of an individual with disabilities under the age of 65. It's federal law that the trust must be created and funded prior to the beneficiary's 65th birthday. The trust can be established by the individual, the beneficiary himself, his parent, grandparent, legal guardian, or the court. Up until a couple years ago, an individual who did not have a cognitive disability was not able to start to create or establish their own trust. They had to rely upon a parent or grandparent or legal guardian of the court. But if we were dealing with an individual who did not have a cognitive disability and was a physical disability, but needed to rely on government benefits, and they were older, under 65, but older, and they did not have a living parent or grandparent, they'd have to go through a protracted, expensive court proceeding for the court to be able to establish the trust. So we had the Special Needs Fairness Act passed in Congress a couple years ago that expanded the statute to enable individuals to be able to establish their own trust. Now, one of the key requirements of a special needs trust, of a first party special needs trust, is upon the beneficiary's death, any assets that remain in the trust are going to be subject to Medicaid payback. And that Medicaid payback it's paid to the Medicaid provider. And in New York, we deal mainly with Department of Social Services or Human Resources Administration, depending where in the state we live. And the Medicaid payback is over the beneficiary's lifetime and not since the trust is funded. And what I mean by that is the trust, if the beneficiary was 20 years old when the trust was established and funded with proceeds from a litigation settlement, and let's say the personal injury lawyer had to settle and pay back a Medicaid claim from the litigation of $50,000. And let's say this beneficiary had significant disabilities and had to rely upon 24/7 care. And so the Medicaid, the provider had paid for a lot of benefits over the years, but it was settled that they would pay back $50,000, and the balance of the settlement went into the special needs trust. And then let's say that 1 year later, the beneficiary died. Well, the Medicaid provider is not going to look at the difference between only the Medicaid that was paid for during that year, but they're going to go back from day one, from when that beneficiary initially applied for Medicaid, whether he was 1 year old, 5 years old, or whatever age it was, and the entire trust will have to be used, or the assets in the trust will pay back the entire Medicaid lien. Also, it's important, and because of that, Medicaid has the first, they have the highest priority to be paid back upon the beneficiary's death, and that's only at the beneficiary's death. I always counsel clients to prepay for funeral expenses, because if the family does not have the means to provide for a decent funeral and burial for their child or the beneficiary or family member, then we cannot use the trust funds to pay for the funeral until after Medicaid has been paid. And it causes a lot of frustration for families when that hasn't been taken care of. So also with a benefit of the first party special needs trust is there's no penalty. So an individual who is receiving SSI or Medicaid receives a $500,000 settlement and is deposited into a special needs trust, and the beneficiary is under 65. Their SSI and Medicaid is not going to be jeopardized. It's an exempt transfer. The assets in the trust are exempt. And any income that is generated from the deposit of the $500,000 and it's invested, and there's income that's earned in the trust, that is not counted as income to the beneficiary for determining eligibility for SSI and Medicaid either. The trust is required to be irrevocable, and certain federal rules require that this trust be for the beneficiary's sole benefit. There cannot be other beneficiaries. And with this type of trust, the trustee, who we'll talk about in a little bit, is charged with many responsibilities. They have a big job and they have a lot of fiduciary responsibility. Why would we want to create a first party special needs trust? Well, one of the biggest reasons is because we need to maintain eligibility or obtain eligibility for means-tested benefits, namely Medicaid and SSI. Because with Medicaid, for example, in New York, an individual, it could be cost prohibitive, or they cannot actually private pay for certain services that are provided through New York State and can only be paid for through Medicaid. Back to when I be at this bottom bullet point, Medicaid payback. So when the beneficiary dies, Medicaid, as I said, gets paid back. The Medicaid is only paid back only for Medicaid, not for SSI or food stamps or any housing assistance, Section 8 subsidies, nothing, only Medicaid. Also, the reimbursement is based upon the actual Medicaid expenditures, not the prevailing costs. So if I hired a nurse and I private pay for a nurse, I may pay $30 an hour. Well, Medicaid may only pay that nurse $15 an hour. And so you'd only be paying back the $15 an hour. And if that was done, let's say 30 years ago, because that happens, you know, because these trusts are in effect for many, many years until the beneficiary dies. And if the nurse was paid $15 an hour back in 2000, you know, or 1990, then you're only paying back that $15. There's no interest. It's not what today's market costs were. Also, any type of special education expenses that were billed to Medicaid are not reimbursable. And so that's an advantage, and that of these trusts is that the beneficiary really needs to rely on these government benefits that are means tested, and therefore we need to have this type of trust. Now, back to the slides where I talked about the couple different types of trusts, the third-party trust, which we're not going to focus on today, the first-party trust, special needs trust, and then there's what we refer to as a pooled trust. And a pooled trust is also is codified in our federal and state law, that it's a pooled trust that's created and managed by a nonprofit organization whose mission is to assist individuals with disabilities. The pooled trust organization creates separate accounts for each individual beneficiary, but then they pool the assets together for investment purposes. This trust is also, we refer to as a D4C trust, unlike the D4A first party trust that I mentioned before, and that is just results back from our federal law. There is a bit of a modified payback provision in that with a first party special needs trust, Medicaid gets paid back upon the death of the beneficiary. But with a pooled trust, in New York anyway, and this is a rule that varies a bit state by state, but in New York, we have the option to actually, for the nonprofit organization, to retain any trust remainder, any remaining funds in their trust to benefit other individuals with disabilities. If they don't do that, then we say then Medicaid does need to be paid back, and then the funds get distributed to the beneficiary's estate. And so where this could be beneficial with the pool trust is that you could, if you know that you're going to have a very high Medicaid lien, and we're dealing with maybe a smaller settlement, and the trust may be used before the beneficiary dies, the trust assets, or the pool trust would hold on to the balance. And one thing that I did not mention before, but when an individual dies with the first party special needs trust and Medicaid is paid back, if there are funds remaining in the trust upon the beneficiary's death, after Medicaid is paid back, then it gets distributed to their estate, to the legal representative or the executor or the administrator of that individual's estate. And if the individual had capacity to create a will, then the assets will be distributed according to the individual's will. If they did not have capacity to create a will, then it's distributed according to the intestacy laws of the estate, of the state where they died in, where they resided at death. Also, one thing that I didn't mention and this goes with the pool trust and the first party special needs trust, is if we are dealing with an individual who may have $100,000 remaining in the trust upon their death, and let's say their Medicaid that they utilized during their lifetime totaled $1 million. Medicaid is only entitled to the $100,000. Okay, not anything. They're not going to go after family members to pursue the difference. Similarly, if there is $100,000 left in the trust and Medicaid, the beneficiary only relied upon $50,000 of Medicaid during his lifetime, then the remaining $50,000 gets payable to the beneficiary's estate, and thus the estate administration needs to unfold. So as I mentioned with the pool trust, the nonprofit organization, the 501c3, will act as the trustee. Similarly to the first party special needs trust, the trust must be irrevocable. And the beneficiary in New York anyway, and this is something that varies state by state, can be any age. However, if the beneficiary is 65 years old or older, there could be a Medicaid asset transfer issue. If the beneficiary needs to go into a nursing home within 5 years of the transfer. Also, if the beneficiary receives SSI, that beneficiary will be disqualified from receiving SSI for a period of 3 years, up to 3 years. And pool trusts are often used in smaller settlement cases. If the settlement is under, and there's no magic number, but I see them in smaller numbers and not your multi-million-dollar settlements. As I mentioned before, special needs trusts are not, they're not the right fit for everybody, or the recommended type of protection for every beneficiary. So other options, and this all depends on whether, oftentimes it depends on whether we're dealing with a plaintiff beneficiary that has cognitive disabilities, or if it's not cognitive and it could be more physical disability, and we don't need to have court supervised guardianships. So if we're dealing with an individual where there's not a cognitive disability, we may spend down the assets, especially if it's a smaller trust and we're dealing with maybe a settlement of $10,000, $15,000. Sometimes we could do transfer of assets to a spouse if the beneficiary, the plaintiff has a spouse. We have certain allowances under the law that allows us to transfer assets that way. Or if the beneficiary plaintiff has disabled children himself or herself, we have certain allowances to transfer assets that way. And sometimes the beneficiary will accept the money. Now keep in mind, with any of these three options, spending down, transfer of assets, accept the money, we're typically not dealing with, as I mentioned, individuals that have cognitive disabilities. And also, we're not dealing with individuals with any of these approaches, actually, who need to rely on those means-tested government benefits, such as SSI and Medicaid. When we deal with minor infants who do not need to rely on SSI or Medicaid, most often their settlement is in a court-supervised guardianship account, overseen by the court. And there's usually a court examiner or a court referee appointed who will examine the accounts on an annual basis. And if there's large purchases, court approval will be required, or sometimes we prefer to enter into a yearly budget so that we don't have to go back to court every time an expenditure needs to be made or requested. And another option, if we don't have a court supervised guardianship account and we're not concerned with, again, maintaining eligibility for Medicaid and SSI, we have settlement trusts where the assets are protected in a trust, generally not supervised by a guardianship account, or maybe there's a modified supervision where we have to do an annual accounting, but we don't have the ongoing oversight by the court and all of the restrictions that could entail. And what I mean by conversion clause is that sometimes when we have children who are under 18, we don't know their lifelong needs. We don't know if they're going to need to rely on SSI or Medicaid. And at that point in their life, they don't need to rely on government benefits. the proceeds of the settlement will typically be in a court supervised guardianship account or in some type of settlement trust. And we would apply to the court if we needed that beneficiary to qualify for SSI or Medicaid at some point to be able to convert the trust or the guardianship account to a special needs trust. Okay. So selecting a trustee. So most often when we're dealing with a first party special needs trust or a settlement trust, we're dealing with a larger settlement and there is a professional trustee involved or a corporate trustee that their business is serving as trustees of special needs trusts and knowing the intricacies of the benefits, eligibility and advocacy. The courts, especially if this is a court-approved settlement, judges typically want to see some professional trustee involved. Sometimes we're dealing with families or parents that don't have the sophistication to be able to understand the investment strategy or the ongoing court oversight and the accounting requirements. And also, and that's not always the case. And certainly if we do have individuals, the court will require, however, that the family or the family member trustee be bonded. And there's oftentimes where the family member trustee cannot be bonded because they don't have the credit history or they have poor credit history and are not able to post a bond. And a bond is kind of insurance that if a bad action happens by the trustee, whether intentional or not intentional, but there's a loss of assets, that the bond, the surety can be used to sort of refund the trust. But then what happens is the bond company will pursue an action against the trustee. So oftentimes there's, individual family members don't have the ability to become bonded. And that's another reason why you'll often see professional or corporate trustees involved. A corporate trustee, you have to, as I mentioned, you need to choose somebody that is prudent with investments. They have to follow the imprudent investor rule. You need to make sure that the taxes are done, that the court accountings are done, or Medicaid approvals are taking place if we're dealing with Medicaid. So the trustee has a lot of responsibility in administering special needs trusts and or settlement trusts. Just a brief note on the New York Medical Indemnity Fund. This is a fund that was designed, that went into effect in 2011 and is intended to provide a funding source for future healthcare costs associated with birth-related neurological injuries as a result of medical malpractice during a delivery, by the parent, by the mother. The purpose of the fund is to pay or reimburse certain costs necessary to meet the healthcare needs of the plaintiff throughout his lifetime. And also the idea was to lower expenses associated with medical malpractice litigation. It's a very onerous process for families to have to go through to be able to get reimbursements or to get coverage to get items paid for. And it is certainly not without its extreme frustrations on many of my clients and trustees. The fund is intended to pay for or reimburse qualifying healthcare costs. And that could be medical treatment, surgical care, nursing care, rehab, durable medical equipment, certain home modifications, and certain vehicle modifications, but they won't pay for the vehicle itself, for example. So what happens is if there is a plaintiff that is eligible to go into this fund, it's almost automatic. You don't have the choice of whether to go into this fund or not. And that is another source of frustration for families, extreme source of frustration. And so that's not an option, and a certain part of the settlement will be allocated to this fund, and the other part of the settlement will be allocated, typically held in a court oversight guardianship account or a settlement trust. The idea was to also not to have to rely on the Medicaid system, but oftentimes we'll have beneficiaries that do need to rely on the Medicaid system because they need certain waivered programs through OPWDD, that's New York State Office of People with Developmental Disabilities, that the fund does not pay for. And so there's an allocation to both this fund and to a trust, and it's a matter of the trustee and the family having to work together to maximize benefits under both. In terms, and then just in terms of the settlement, there's ongoing oversight. As I mentioned throughout this, the court is routinely involved, especially if we're dealing with an individual with a cognitive disability. Annual accountings have to be filed. If we are requesting a large purchase, such as for a vehicle, a van, an accessible van, or even a vacation, a trip to Disney World, or a modification to a home, or we oftentimes have to go and petition the court, and Medicaid gets notice of the proceeding, and they have the right to file objections, and the court has to approve the purchase. It's oftentimes hard to hire lawyers because sometimes the court, in order for lawyers or accountants to be able to be properly reimbursed, they have to petition to get court approval of their fees, and it's not always dollar for dollar, and so that causes frustration for attorneys as well as for families to be able to hire competent counsel to be able to help them navigate through this process. There is ongoing government agency notifications and approvals, mainly to Medicaid, to the local Department of Social Services. The investments of the trust have to constantly be monitored. For example, I mentioned before, if a structure, if part of the settlement is in a structure settlement, and the family or the beneficiary was planning on purchasing a house with the settlement, but there wasn't sufficient assets to be able to purchase a house with the stream of income coming in, there wasn't enough allocated, then that causes some frustrations, to say the least. We need to look at the tax strategy of ongoing tax strategy of the settlement and the special needs trust. And then upon the beneficiary's death, wrapping up the trust, certain court approvals and discharge proceedings are required. That concludes my presentation. I don't see any comments here, so I'm just going to so I don't know if anybody has said any comments, but Kian and Maria, if you're listening, I don't have any questions that are popping up on my screen here. Maybe you could cut and paste them, because Kian, I could see the only person I could see is you, Kian. So maybe you could cut and paste it into the window for me. Okay, so we don't have any questions. That concludes my presentation. Thank you very much. If you missed any of this, check back at our website in the next couple of days, because this will be posted on our website. Thank you very much.